Welcome to your key discovery point. My name is Brett Burney from Nextpoint, joined by Doug Austin of eDiscovery today. Doug, you recently covered a case that highlights the critical importance of A, lawyers having the technical competence to understand native files versus PDFs in different formats, and then B, making sure that you're not misrepresenting those technical distinctions to the court, or you might face a forensic examination order. Ooh, this is a good case, though.
Yeah, and I would say if you're lucky, because
Right.
this is a case where I think the court has been very patient with the counter defendant, and in essence, what's involved here is that I think because of discovery disputes and I think mistrust on the on the from the defendant's side to the counter defendant.
Mm-hmm.
The Mintas, the defendant, has on two different occasions requested that the court order a forensic examination of CIMIC's data, and in each case, the court denied the motion without prejudice, giving CIMIC a chance to kind of address his issues, basically telling him to undertake a thorough search for responsive documents. The CIMIC the first time tried to say, "Oh, these documents are in my possession, custody, control
Right.
because they're with the company I worked for," and the court rejected that. And then basically also ordered them to detail his search efforts, including specific identification of each item account searched and the manner of search. That one didn't go well either, so
Right.
Mintas filed a third motion. And one of the things that, there really were three issues. And the issue that I think was most discussed here was the first one, the FTX meeting notes,
Mm-hmm.
where in essence, prior to close of discovery, CIMIC produced two documents, one of which was these meeting notes that were CIMIC 004. That was even though he was ordered to produce the documents in native format, including
Right.
metadata, he produced it as a PDF that was created the day it was produced. So that's
Mm-hmm.
interesting. And then what the Judge Koppe notes is that Mintas provides evidentiary support that the document had been altered, providing
Ouch.
basically obtaining an email from one of the board members of PlayUp who was attaching a different version of the same meeting notes. So, basically what the judge is doing is relaying kind of Mintas's contention that the PDF had been altered for litigation advantage, that he violated the court's order to produce an version, and he violated that order as a bad faith tactic to avoid confirmation of his evidence manipulation. So he says, so
Wow.
the Judge Koppe says that, and then she notes. And I didn't, because for space considerations, I didn't put everything into the blog post. She said, these types of substantiated accusations of bad faith discovery violations should be the stuff of nightmares for any attorney. And yet, the
Right.
response to the pending motion ignores the issue, providing no rebuttal or argument of any kind. So they go back and forth more on this document. First, Senate counsel claimed no native format existed, then suggested the client might be withholding it. Let's pass the buck. And then finally,
Right.
produced it. They produced they basically talked about an Apple version of this file, but then they produced a native Microsoft Word version.
Right.
So, it just was a lot of kind of shady, kind of weird stuff that, as Judge Koppe said, given the repeated misrepresentations, the court has no confidence in the accuracy of the current representations made to regarding the document, including whether the actual native version has truly been produced. So that was one major issue, and certainly when you're talking about the claims of altering a document for litigation advantage, those are serious claims.
Yeah, I was
But
just gonna jump in. Like the judge, I thought did an excellent job of discussing, more of even some of the technical issues, as you know, I am prone to like focus on a little bit. But there was discussion of like it was from the Apple Notes version. In other
right, the
words,
Apple
that
News.
would tell me that they're taking notes either on an iPhone or maybe a Mac laptop, something like that. These are Apple
Right.
Notes, which a lot of people know about. And if that's where they took the notes, then you can export out of Apple Notes, even as you can export as a PDF file, or you can
Mhm.
export out as even a text file, a simple text file. It doesn't export out into a Microsoft Word document. But here they were talking about the Word document. Anyway, again, I think Judge Copy does an excellent job of going through and not just showing the frustration here where she is not happy with kind of the different answers that she gets, but more in so she drills into the counsel for the counter defendant Simic here, and just like, is it a native file or not? And then like she even has like quotes from the transcript, and which is not good because you don't want to be caught in something like that. And how you're saying, is this a native file? Is it not a native file? Did they create a PDF? And just the fact that, I tell people a lot of times, Doug, the metadata of files probably doesn't matter too much until it does, right? Which is why
Right.
obviously we talk a lot about when you do that collection and the preservation, maybe collect that native file, the original file when it was created, and you can always generate a PDF from there if that's how you're going to produce it, for example. But having that
Mhm.
native file means that you also have all of that metadata, which in this case I think could have helped or maybe not have helped. It may have been able to clarify some of the questions that the judge was asking, and certainly the opposing party was asking.
Sure, and one of the things that you have to give credit to the defendant who kept pushing and pushing. I think
Right,
in one of the earlier attempts to get a forensic examination, I think that was where Simic was then ordered to produce the files natively with metadata. So
right,
that
exactly.
basically led to all these additional challenges where the defendant didn't do that, and then there was kind of questions as to whether the document had been altered. And that's absolutely one of the keys there. Parties still in this day and age don't always agree to produce natively with metadata, but there are times where it's absolutely justified. And as
Right,
you're going through the other couple of considerations there in terms of what CIMIC did from a search standpoint, didn't necessarily provide enough detail on what was searched, and I think there was question as to whether those, the different sources were adequately searched, and no proper declaration on search efforts. And then, despite the request basically establishing a time period, the CIMIC apparently limited his search or focused his search on just a few months within one of those
right,
years. So, there's clearly, a couple of places where, a self-selection of a time period, was, and how the search was conducted. There were certainly a lot of questions about it. So, basically, Judge Coffey said, Mintas has made a strong showing of discovery misconduct,
hmm
and reiterated the things that Simic was found to do, and she also found that lesser remedies are not feasible in the case. So she not only ordered the forensic examination, but adopted Mintas's proposed protocol for the examination as well. So it will be
yeah,
interesting to see what comes of that, given the current history of this case, and will maybe sanctions follow if it appears that maybe evidence might have been spoliated, tampered with, what
yeah,
have you. Who knows? I mean, we'll see. But certainly, the court tried every which way to not go to the point of ordering
right.
a forensic examination, but it just got to the point where she had no choice. And yeah, it's these are the types of cases where a forensic examination is certainly warranted.
And just so anybody doesn't think like, was this sprung on, like requested a little bit later, I think somewhere in the opinion here, Judge Copy even talks about the fact that it's quite apparent that these notes are incredibly important. Like it wasn't like it was something surprise. Like this was a very important meeting toward the end of this disagreement here with a company selling another company or acquiring a company. And so, in other words, it seems like the counter defendant here obviously should have known that this should have been preserved in whatever way that it could have been properly preserved and then presented. Let me just also say quickly, the standard section in Judge Koppe's opinion here is absolutely fantastic. I mean, I'm even, I think I told you earlier, I think I'm going to try to use some of these quotes in like my presentations. She just does a really good job of kind of going through, or her clerk does a great job of just going through exactly what the standards are, that need to be proved here, and not just from a discovery process, but also when it is important to require a forensic examination on here. And I just thought that that was a really excellent job on that opinion there.
Yeah,
And
absolutely. And I'll just real quickly, yeah, that sentence that says the honor system, you can go back. Yeah, the
yes,
honor system
yeah,
for discovery works in the overwhelming majority of cases, but the word of a litigation opponent is not sufficient in every case. And this is certainly, she's tried to give the party the benefit of the doubt two
right.
times and denying without prejudice that request for forensic examination. But at a certain point in time, she's just realized there's no other choice.
That last point on that how did you word it here? Self-selection of a limited time period just got me thinking of self-collection, another topic that we talk about quite a bit in the eDiscovery neck of the woods here. Here's a great blog post that we have been sending out to a lot of folks from Nextpoint. Don't let self-collection spiral into self-destruction. And we just walk through some of the potential pitfalls and risks about clients collecting their own data. I'm not really sure exactly how that happened here in this case, but I can just sort of read between some of the lines in the opinion here that it looks like counsel, maybe for this counter defendant, at least wasn't being completely aware of how we were actually collecting and preserving some of those documents, which obviously is an important time to just make sure that you're working with somebody that understands that, right? It comes down to the technical competence, not just in technology itself, but even in how that applies to eDiscovery and discovery overall. Great stuff
Yeah.
as always, Doug. Yeah, go ahead.
Yeah, I was going to say absolutely. Yeah, like we've said many times, Judge Peck talks about bring your geek to court.
That's
Get your
right.
geek involved. You may not have the technical knowledge, but you want to have you're still, as an attorney, responsible for the evidence that's produced. So you need to make sure that it's done in a technical manner, especially when the court is requesting a native format with metadata, that you've got
Exactly.
somebody who knows their stuff.
Always interesting to talk with you about cases, Doug. Thanks again, and we'll talk with you again real soon.
Thanks, Brett. Thanks, everybody.